Hi, I'm John Kelly. I'm doing a 7-part series on vulnerable adults. This is chapter 4 in that series that is going to go over protecting your loved ones and reporting. So the first moves in protecting your loved one is reporting and building proof. If you're watching this, you may be at a crossroads. You feel something is wrong. You're trying to decide what to do without making things worse. In this chapter, we'll talk about immediate safety steps, reporting options like Adult Protective Services and Ombudsman, and if the case becomes legal, how we prove neglect or abuse when the evidence is scattered and the vulnerable adult may not be able to testify clearly. I'm here to help you understand and navigate what can feel overwhelming. We've talked about how harm happens and what it looks like medically. Now we can move to action. And I'm going to be blunt here. In many facility cases, time is your enemy. Wounds will evolve, bruises fade, videos get overwritten, charts get cleaned up, witnesses leave. And the resident's condition may worsen, sometimes quickly. So the goal is twofold. 1, protect the person now, and 2, create an outside record that can't be rewritten later. Step 1, safety before strategy. If your loved one is in danger, don't negotiate with the facility. Don't wait for Monday. Don't accept. We'll look into it. Get them medically evaluated. That may mean calling 911. That may mean taking them to the ER. That may mean insisting on a provider assessment now. And here's why. Hospitals create independent records. EMS creates records. Imaging creates records, lab work creates records, and those records are often the most trustworthy snapshot of what was happening at the time. If you suspect abuse, especially sexual abuse, tell the medical provider that you suspect abuse. Use that language. Don't soften it or anything like that. Medical terms can activate protocols, and they can document findings that matter to us later. Step 2. Reporting. You want to create an outside track of accountability. So families often ask, who do I report this to? There are usually several channels that they can report to, and they serve different purposes. Adult Protective Services, or APS. APS exists to investigate abuse, neglect, exploitation of vulnerable adults. And in many states, filing an APS report is one of the most important early steps because it creates a government record and it can trigger an investigation. Sometimes people refer to adult abuse reports with shorthand terms depending on the state or intake system, what you call ABSA style reporting concepts. The key idea is the same. You are creating an official report that a vulnerable adult may be unsafe. APS can interview, obtain records, coordinate with law enforcement when needed. The process is not perfect, but it matters and it often gives you leverage. Now, there's the long-term care ombudsman. The ombudsman program exists to advocate for residents in long-term care facilities. They can help mediate issues, push for improvements, guide families through complaints. The ombudsman is not a law enforcement. They are not your lawyer, but they can be an important ally, especially in getting facilities' attention and documenting the problems that exist. There's also licensing and survey agencies. Most facilities are licensed, and some are certified under the state and federal rules. Filing a complaint with the licensing agency can trigger surveys, inspections, and citations. Again, the system is not perfect, but a survey finding can be powerful evidence because it's an outside authority saying this facility failed to meet its standards. If there's a crime, an assault, a sexual abuse, theft, serious physical harm, call the police. Do not let the facility talk you out of it. Facilities sometimes refer to keep everything internal. That is exactly why external reporting exists. Now, an important reality check. Reporting can be emotional. It can feel confrontational. It can feel like you're accusing people. But the purpose of reporting is not to create drama. It's to protect the person who cannot always protect themselves. Step 3, Document like you're building a timeline, because you are. If you suspect harm, start documenting immediately. And there's family-facing documentation tools. You can photograph injuries and wounds, photograph the clothing, the bedding concerns, get the environment in the photographs. Keep a simple log of dates, times, of what you saw and who you spoke with. Try to log what they said and save their texts, emails, and voicemails. Request care conference notes and written plans, and write down the names of the staff you interact with. This is not being paranoid, it's about being prepared. Attorney-facing documentation goes deeper, and it should start early. Attorneys like myself will send an early preservation letter that will target all medical records from the facility, including EHR metadata and audit trails. It can target care plans and service plans, MARs and TARs, wound logs, wound photos, and treatment orders, weights and nutrition records, CNA flow charts, ADL assistant documentation, toileting logs, incident reports, and internal investigation materials. It can also include staffing schedules, assignments, agency staffing records, call-outs, training records and competency checklists, prior complaints, surveys and correction of action plans, where discoverable, video footage, hallway cams, entrance cameras, common areas that have cameras, and retention policy. We can trigger communications that they have within the facility, including emails, text, internal messaging about the residents. Why this matters? In modern facilities, the chart is often electronic, and electronic records can be edited. Audit trails, who charted what, when, and what was changed can become quite key in unlocking the full story. So step 4 is choosing the legal theory, and your attorney can help you determine negligence versus medical malpractice versus statutory abuse. Facility cases can involve multiple legal theories. The best cases often do. Negligence is the first to cover. This is the baseline: failure to use reasonable care. Negligent supervision, negligent care, negligent staffing, negligent falls prevention are all types of negligence that we can plead. Now, some facilities' harm is truly medical. Wound care decisions, medication management decisions, failure to escalate to providers, failure to follow discharge instructions, failure to monitor a known condition. Depending on the state, medical malpractice has different procedural requirements. There's experts, affidavits, shorter deadlines, damage limitations, so on. So you need to analyze early, and we are in mid-mal territory, negligence territory, or both is a question that you can ask your lawyer. Corporate negligence. This is where the story gets bigger than the one caregiver. Corporate negligence is about system failure. That is understaffing, the lack of training, poor hiring and retention, poor policies and culture that tolerates shortcuts. If the facility is chronically understaffed, that is not a random event. It is a decision. And if that decision foreseeably causes harm, corporate negligence becomes the spine of the case. Physical abuse and sexual abuse can implicate battery, assault, and intentional misconduct. These claims can change the case value and the emotional narrative, and sometimes open doors to punitive damages. Many states have statutes designed to protect elders and vulnerable adults, sometimes with enhanced remedies when neglect is reckless or when the conduct is particularly egregious. There isn't one set of statute that fits every state. Every state is a little bit different, but conceptually, these laws recognize something important. Abusing or neglecting a vulnerable adult is not just ordinary negligence. It is a betrayal of a special trust. When the neglect leads to death, the legal framework often includes a wrongful death claim. The family's losses is what that is, and the survival claims, the decedent's losses before death. And this is all depending on jurisdiction, how it's pled. There's a hard truth In many facility cases, death is the defense's strategy. Not explicitly, of course, but practically. Because if the resident dies, the defense often assumes the case value drops. They were old, they were sick, they were going to die anyway. My job as an attorney is to burn that argument down with dignity and detail. Yes, they were old. Yes, they had conditions. And yes, they deserved safety, comfort, and basic care. They still had a life, and they did not deserve a preventable, painful death. Step 5, proving causation when the resident has comorbidities. This is where the cases get technical. Vulnerable adults often have comorbidities. They'll have dementia, diabetes, kidney disease, heart disease, maybe mobility impairment, prior strokes. Defense will try to blame the injury on the baseline. They will say the decline was inevitable. Sometimes decline is inevitable. Neglect is not, though. Causation in these cases is often about acceleration and aggravation. Did the facility's failures accelerate decline? Did they turn manageable condition into a crisis? Did they transform the risk into harm? If a resident was walking with assistance and a preventable fall broke their hip, that is not inevitable. If a resident has dementia but was stable until dehydration and infection caused delirium and a fall, that chain matters. If a resident had fragile skin but the facility failed to reposition and a stage 4 wound developed, that wound has causation roots. This is where medical records, timeline, and expert testimony converge. Step 6, the experts. Translating care failures into the standards. In facility cases, the right experts often include nursing experts to speak to the standard of care for supervision, the skin care, the infection prevention, documentation, and staffing, wound care experts for pressure injuries, geriatricians for internal medicine physicians for causing decline patterns and preventability, pharmacology experts for medication errors and chemical restraint themes, psychiatrists or neuropsych experts in cases involving behavior, delirium, or cognitive baseline, life care planners and economists for future needs and valuation. In some cases, facility administration experts who understand the staffing, they understand the budgeting, and the operational decisions. Your experts should not just say negligence, they should explain the practical why. This is what a competent facility would do. This is what this facility did instead. And this is how that difference caused the harm. And if you can, pair that with the simplest possible human truth. This didn't have to happen. A note on facility cooperation. Don't expect it. Families often expect that if they raise concerns, the facility respond transparently. Sometimes they do, but often, once a facility senses exposure, the tone changes. You may see defensiveness, minimization, blaming the resident, or sudden claims that everything was documented. As an attorney, such as myself, I anticipate these things. As family, you shouldn't take it personally. It's not about you, it's about liability. Now let's tie this together with a quick story. Imagine a resident, Miss Lee, who develops a pressure injury. The family notices it on Saturday. They're told, "We just noticed it too." They take photos. They take Miss Lee to urgent care, and the provider documents advanced pressure injury with signs of infection. An APS report is filed. A complaint is filed with the licensing agency. When an attorney like myself later gets records and facility charts show skin intact through Friday, but the wound is too advanced for that timeline to be credible, now the case has something powerful: outside documentation, the photos, the independent medical assessment, and a question about the honesty of the charting. That's how you build proof. Now that we talked about safety steps, reporting, and the foundation of providing these cases, we're ready for the next chapter, because once you establish what happened and why it mattered, you have to answer the hardest practical question: what is it worth? In the next chapter, we're going to talk about damages in vulnerable adult abuse cases and neglect cases, and the economic damages. We'll talk about non-economic damages and the themes that create high-value cases. Pain, dignity increases, care needs, loss of independence, and wrongful death pathways. We'll talk about how to translate quiet suffering into a damages model that a jury can understand and an insurer cannot ignore. So if you have a family member or a loved one that's a vulnerable adult and needs help or questions answered on a situation that we've discussed, we're happy to help. We do these cases around the nation. You can reach us at any time at 602-283-4122, the Kelly Law Team.